But there is something. Still waiting. Um,
All right. Good afternoon, Council.
Good afternoon, Judge.
Hello, Your Honor.
And some names you may not recognize also on the screen there with this. I think you recognize Susan Schaefer. I think Ms. Walker is working in Ms. Schaefer's office. So they are just casual participants for our proceedings today. Well, let's go ahead and start. I have read the correspondence relating to the issues with the financial records. And Counsel, I apologize. I do not remember the correct pronunciation of your name. Is it Tati or Toddy?
Toddy.
Toddy. I was going back and forth between Tati and Toddy, and I wasn't sure which one, but let me just go ahead and get that out of the way before I start mispronouncing your name.
Thank you. You're very close.
So I'll let you go ahead. Just focus me again on what you think you're missing that you're entitled to.
Thank you, Your Honor. We contend that the defendants have violated the court's March 18, 2021 discovery order to provide CurePoint's financial records and certain ledgers in native format by April 1. So there's two issues basically. There's the due to, due from ledgers from CurePoint and PFP. And then there's the second issue of whether or not we have actually received production or access to all of CurePoint's financial records. As to the first category, defendants assert that they have produced the ledgers, these due to, due from ledgers for CurePoint and PFP in their original native format. But defendants' own contentions indicate otherwise. It is clear that the spreadsheet that was produced on April 1st, and there's actually two spreadsheets, one for CurePoint, one for PFP, and we have more information about the spreadsheet for CurePoint, so I'll focus on that one. It's clear that data was removed from that spreadsheet before it was produced. Mr. Philip Miles, one of the defendants in the case, who has now provided an affidavit to the court this morning, testified that the CurePoint ledger, he called it, was a single comprehensive spreadsheet. And let's see here, if I can, I'll let you share. Yeah, if I can share screen here, that'd be great.
All right, you should be able to share now.
Yes, thank you. So we can look at Mr. Miles' deposition testimony here, and let's see if I can make this a little bit bigger. So he was asked if CurePoint owes or is owed from PFP, Physician Financial. I'm sorry, this is his testimony. I know, he says, I can find that number to the penny or to Zero Holding, which is one of the entities that Philip Miles owns, or to any other entity. So then we asked him, what I'm trying to get a sense of is how many different ledgers we're talking about. Is it just one for CurePoint and one for PFP? Mr. Miles says, let me, Brian, if I can just try to explain it. Mr. Raley says, sure. Says, so it's on Excel, and it might have 100 entities. Then in Excel, you go, what is the net for that entity? Perhaps Zero Holding. For this entity, perhaps PFP, and it's summed. So it's not a separate ledger. It's all in one comprehensive ledger, and it's summed to the various entities. Follow-up question. So it's one comprehensive document. Response, that's correct. So what we're talking about here is a single ledger, a single due to, due from ledger for CurePoint, presumably one also for PFP. Mr. Miles also testified that this spreadsheet, this single comprehensive spreadsheet, was started before January 2018. So the question here, starting on line 7, and how long has that ledger been in existence? Response, I would say for at least 2 to 3 years. Question, did you start it after January 2018? Answer, no. When was it started? I mean, can you bracket it to an event or a year? Answer, 2016 or 2017. The spreadsheet that defendants produced on April 1 was created by someone named Michael, presumably Philip's son, Michael Miles, shortly after the court's March 18 order was entered. And I can, let's see here, I'm going to stop sharing on that. And you can see here, here's the cure point due to, due from. The properties details show Michael, content created March 23rd, 2021. Now, and that's the same thing for the PFP spreadsheet. I don't know that we need to focus on that right now. In Mr. Rayleigh's letter that he sent this morning, he says that defendants had previously produced quote unquote reports from 2014 through the summer or fall of 2018. In other words, defendants have data going back to before 2018, but they did not produce it on April 1 as the court required. Rather, they provided a spreadsheet that was created by Michael Miles, presumably Michael Miles, after the court's March 18, 2021 order. And it did not contain prior data, which defendants admit existed, and that Philip Miles testified in his deposition was included in this single comprehensive spreadsheet. Because we are streaming live on YouTube, I'm not going to pull up the spreadsheet itself because it's been marked confidential, but the spreadsheet only goes back to January of 2018. It does not go back to prior years. So after we notified opposing counsel, Mr. Rayleigh, of these obvious deficiencies in the spreadsheet that was produced on April 1, defendants produced a different spreadsheet. So laying aside the fact that the court had already ordered defendants to produce all of CurePoint's financial records, and this new spreadsheet should have been produced on April 1, laying that aside, this new spreadsheet is totally different from the due to, due from spreadsheet produced on April 1st. It's got a new name, cash in outflows. Now, Mr. Miles contended in his affidavit that he submitted this morning to the court that he and the other folks there at CurePoint use those two terms interchangeably, due to, due from, and cash in outflow. But that doesn't explain why there's two different spreadsheets produced within a few weeks of one another with very different formatting, when Mr. Miles testified at his deposition that there is one comprehensive spreadsheet that goes back to 2016 or 2017. His testimony is clear on that issue. Defendants have not answered that question. So in fact, defendants have violated the court's order. If this recently produced spreadsheet, this cash in / outflow spreadsheet, was the one that was described in Mr. Miles' deposition transcript, it wasn't produced on April 1st. It was produced several weeks after the fact, or several days after the fact, after we complained about the deficiency. So moving on to point number 2.
All right, let's take it one point at a time. So,
Sure.
And that'll help me crystallize the issues in my own mind. So, Mr. Rayleigh, I have to admit, I have some confusion over what records are denoted by what names and what exists in different formats. So tell me what's going on.
Your Honor, two points with regard to this initial issue. First, the due to, due from that was produced on April the 1st. Number one, that document existed on CurePoint and PFP's system. Now, counsel has again, he said to me, well, it looks like they created this document. It looked like they stripped data from this document. They did all those things. None of that happened. And we have offered sworn testimony today to sort of take some of the speculating and guesswork, et cetera, out of it from the plaintiff's side. That is not what happened with that first due to, due from that was produced. That was a document that was maintained on their system. The only change that was made to that after Your Honor's order is that report is not updated on a regular basis necessarily. It's not a monthly, weekly sort of thing that they update. So they updated it for I believe it was just the last couple of months of 2020 to bring it to 2020, and I believe they included the first month of January 2021. So they added some additional information to that 2018 report, and then that is what was produced. So there was, I don't know that it's material now given what information the plaintiff has received and unquestionably has in their possession. But just so the court understands, that document was not something that was created. And Mr. Toddy and I had been back and forth in terms of when you make changes to a document, how it could alter the created by date that he pulled up a moment ago. There are different ways that can happen, but regardless, so that spreadsheet was provided. It was 2018 up through the early part of 2021. Mr. Toddy reached out and he pointed out the provisions that were included in the deposition. I went back to the client and I said, let's go through this again. We're producing everything that we have. I think their confusion, and I should have caught it the first time through, was the inflows, outflows spreadsheet. That is the document that Mr. Miles was referring to in his deposition. There's even a part in the deposition where it is shown, Mr. Barton, who's not here today, was taking the deposition. He showed an inflows, outflows while he was asking Mr. Miles about the due to, due from. He said, is this the kind of document? Mr. Miles said, this is the type of document I'm talking about. And that report contains, I would be happy to provide it in camera for the court to review. That is a broader spreadsheet. It does go back to 2014. In fact, I think one of them, PFP, I believe starts in 2013. But the supplemental production that we provided in native format goes all the way back to 2014. It contains more columns than the original, the initial production that we provided, the due to, due from. But you can go through those columns and see that they tie. I mean, there are entries on it's hundreds of columns of data. And if you compare those to the due to, due from 2018 forward, you can see in large part how they tick and tie. But so in response, Judge, what I would say is this: I will agree, we should have produced the inflows, outflows at the start, and I will take the blame for that with my client for, again, I was hammering on due to, due from, due to, due from, and they were focused on the 2018 forward because they knew that they had already provided hard copies of up to 2018 pursuant to an order earlier in this case. But the moment that Mr. Toddy reached out, I connected with my client. I went through it again with them, and we provided in native format the inflows, outflows, which is they use interchangeably. It's a due to, due from, inflows, outflows. Those things. They title the documents one way or the other, but they mean the same thing. They're showing the money in and out. And we produced that over a month ago. And so, to that issue, my question is, what I've continued to ask of Mr. Toddy is, what is it, the same question Your Honor asked, what is it that you say you don't have now? if you're asking for, and one point, Judge, with regard to the inflows, outflows, comprehensive spreadsheet that was produced, that document itself, I think I saw the complaint in the letter somewhere, that document says created by Jamila. It has a 2018 created by date. And I think, I know at least in one of my communications with Mr. Toddy, he complained saying, well, Philip said that it was created in 2016 and that only Philip had access to it. And to that point, Philip offered an explanation as to why he thinks the create date showed as 2018, because his computer was taken for a while by plaintiff's family. But the creator of the document reflected on the native format of that document. The fact that it says Jamila, who is Jamila Databoy, who's the managing member of the entity, I mean, that doesn't, if I borrow a letter online from one of my law partners, the format, and then I adjust it and use it for the next 10 years, that letter will still say created by my law partner. Doesn't mean that it's not the document that I've been using for 10 years. And so the fact that Jamila's name is on there as the initial creator, I give you that example, Judge, to say I think Mr. Toddy I don't believe he's going to be satisfied and until there's a document that says created by 2016 Philip Miles, period. And that document doesn't exist. I mean, the documents that we have provided, the comprehensive inflows, outflows, that is what we have. There aren't any other documents. And so, my question to him is the same as yours. What is it at this point that you don't think that you have? We've been trying to get that question answered, because there's not a due to, due from dated 2016 that says Philip Miles that is somewhere in our system that we haven't provided. We have provided what we have on this issue completely. And I think that's confirmed by Mr. Miles' affidavit that we submitted today.
All right, let me ask you this question, because, there's the first spreadsheet, and then there's the second that's appears to be larger and more comprehensive. And I know when you're dealing with these kind of databases online, there are various ways to cut the data. Is there a more complete or comprehensive way to cut this data? I mean, is there anything that's being left out, right? Any category of information that's being left out of this latest inflows, outflows sheet that you produced?
No, Your Honor. I mean, and I have been through this with my client up and down, up one side and down the other. I mean, in addition, and I think some of the points we'll discuss with regard to the CurePoint financial records, which were provided and we're going to talk about today. Other than the only thing I would say with regard to the spreadsheets, the inflows, outflows, is they have not, I believe that they run through January of 2021. And I don't think, as I said, these are not updated on any specific weekly, monthly, bi-monthly basis. They're updated sort of on an as-needed basis. And so other than those documents being updated up through, May 25th, that's the only information that is not included there. And in fact, I've already, as the court will recall, we acknowledged our duty to supplement these responses, and I have already instructed the client to begin preparing those updates, so that we can supplement up to current. But that's the only thing, Judge, that is not included with regard to that area of data.
So, Mr. Toddy, let me come back to you. The representation is that this is the complete encompassing spreadsheet that they produced. You still have reason to doubt that?
Yes,
you got to give me a specific reason. I understand that you're a discerning and dogged plaintiff's lawyer looking for the truth, but I need a little something more other than suspicion, which you can
It-
You know, you can amplify those suspicions and discrepancies on cross-examination, but you know, I need something that I can sink my teeth into if I'm going to find that somebody's willfully violated a discovery order, or I'm going to order something else produced that hasn't been produced. I need something to sink my teeth into other than sort of suspicions that this is not everything.
Uh, Your Honor, the only thing that I have is the fact that we were given a spreadsheet on April 1st that was not complete, that did not comply with the court's order, that we believe was created for the production. And I think the admission that the admission that Mr. Raley just made, that this cash in outflow spreadsheet is the actual spreadsheet, indicates that the spreadsheet that was produced on April 1st was in fact created for this production. Because Mr. Miles, again, testified unequivocally, we've got a single comprehensive spreadsheet. So if Mr. Miles is now swearing in an affidavit that the spreadsheet that was produced later is in fact the spreadsheet, that's fine as to point number one, but it raises serious doubts in my mind about point number two, category number two that we're about to talk about.
All right, let's talk about point number two.
So category number two, we're talking about all of CurePoint's financial records in native format. It is undisputed that CurePoint maintains at least some of its financial records using QuickBooks Online. The spreadsheets that defendants produced on April 1st are purportedly from those QuickBooks records. But those spreadsheets obviously were not created in a vacuum. The data in those spreadsheets came from somewhere. We've got profit and loss statements. I'm trying to remember everything that's in there. There's accounts payable reports. There's monthly balance sheets. There's a lot of different reports, but there's no spreadsheet with the underlying data that went into the creation of these various reports. I mean, there's payroll reports as well. There has to be underlying data from somewhere. These spreadsheets didn't spring into existence on their own. So after we notified opposing counsel of this additional deficiency in defense production, opposing counsel, Mr. Raley, stated that there are in fact other records from which these spreadsheets were derived, in addition to the QuickBooks records. The defendants claim that data is not kept in QuickBooks. The source, well, defendants claim that the data comes from various sources, but apparently primarily from bank records, bank statements. Defendants assert in the affidavit and in the letter that they submitted, that they sent the court this morning, that CurePoint has never objected to Dr. McCord's efforts to subpoena bank records from CurePoint's bank. The truth is, Your Honor, that we have issued 4 rounds of subpoenas in this case to various banks, and defendants have filed motions to quash 3 of those rounds of subpoenas. So in fact, we have fought tooth and nail for these bank records the entire time. We issued a round of subpoenas early on in this case. Defendants filed a motion to quash in May of 2018. The court denied that motion in August of 2018. There's a second round of subpoenas on October 17th, 2018. Motion to quash was filed on October 29th, 2018. And then the court entered an order effectively denying those motions on December 12th, 2018. We did another round of subpoenas to banks in September of 2019. Again, a motion to quash was filed October 2nd, 2019. And again, the court denied that motion to quash in an order entered November 21, 2019. So the truth is, we have fought tooth and nail for these bank records. And in fact, we sent a subpoena directly to CurePoint, asking CurePoint to produce its bank records. CurePoint did object to that subpoena. It ultimately did produce some bank records, but initially it fought that as well. Defendants also contend that they have given my client, Dr. McCord, everything in the QuickBooks records, but just via spreadsheets. We haven't been given access to the QuickBooks records themselves. We've just been given some spreadsheets that defendants tell us came from the QuickBooks records. Given the shenanigans and the wordplay that has gone on with these other with this due to, due from, and some of the other discovery issues, frankly, we don't completely trust what defendants are telling us. The court ordered production of documents in native format, all of CurePoint's financial records in native format. We've been given spreadsheets that were derived from QuickBooks records. Accordingly, Dr. McCord is entitled to access to CurePoint's QuickBooks online files. Defendants can provide the username and password to those records. They can provide an administrative username and password that only gives us read-only access to those records. And that can be done immediately. They can be done this afternoon, and there's no reason for delay on that. Now, Mr. Raley argues that Dr. McCord is a competitor, but there's a protective order in the case preventing any use of these confidential documents for anything other than this litigation. Additionally, Dr. McCord's an owner of CurePoint, and therefore he's entitled to access to these records. In any event, if what defendants say is correct, that they have already produced every scrap of data in the QuickBooks records, then there's no harm in giving us access to the QuickBooks records. There's no harm in giving us access, read-only access to these records to confirm that. Additionally, Mr. Miles testified that CurePoint used a different accounting platform prior to I think it was prior to January of 2018. He also testified that when CurePoint's use of that prior system ended, they downloaded the data from that system and then put that data into QuickBooks. Well, that data hasn't been produced. No production on April 1 or on April 1st for anything prior to January 2018. So in conclusion here, there's abundant evidence to support our suspicion that we have not been given everything that's in these QuickBooks online records. It's very simple and very easy for defendants to give us an administrative password and username that gives us read-only access to those files, and we can look at the records themselves. So really what we're asking for the court to do is to require defendants to produce, in truth, all of CurePoint's financial records in native format, including by providing immediate access to CurePoint's QuickBook files online.
But it's my understanding that the way you read QuickBooks is on some kind of spreadsheet program, right? You can't just, it's just gobbledygook if you're just getting raw data, or it's not manipulable in any coherent fashion unless you have some type of spreadsheet program to view it through. Now, they did produce it on an Excel spreadsheet, right?
They produced Excel spreadsheets, yes, but
and in spreadsheets that you can divide and cut into different and sort into whatever way you want to sort it, right?
No, Your Honor. Unfortunately, no. The spreadsheets are reports. They're profit and loss reports. They're accounts payable reports. It's not there's no general ledger type document. There's no general ledger type spreadsheet from which data could be extracted and manipulated. What we were given was dozens of individual spreadsheets that are reports generated off of QuickBooks. We don't have the underlying data. And what we're asking for is access to that underlying data so that we can confirm that what defendants are telling us is correct.
Were you given the data electronically?
No, the underlying data, no. We were given spreadsheets, Excel spreadsheets that were created using presumably QuickBooks data. But
right,
the underlying data itself, I'm sorry, go ahead.
These are not printed hard copies. This
I'm
is,
sorry, Your Honor, I'm sorry, I did not hear you.
are we talking about printed hard copies? Or are we talking about a computer file in Excel format?
What they produced is dozens of individual computer file Excel spreadsheets that were derived from some underlying data. We don't know from what source. We don't have the underlying data. All we have are reports, individual reports like monthly reports or annual reports put into spreadsheet data. We don't have the underlying QuickBooks data itself. And that's all we're asking for.
And the underlying QuickBooks data is what?
It would be the data that was used to generate these reports that were produced to us.
I'm not sure I understand it. I'm not sure I understand what you're getting at that you don't already have. If you have bank statements that are used to input the data into QuickBooks and generate a report from that, then you have the underlying data, perhaps not in the most usable format you would want to have the underlying data, but you have it. I'm not clear that there's something else out there that you don't have that was used to generate the QuickBooks data.
Well, Your Honor, a couple of points here. First off, I'm not sure we have all of the bank statements. I'm not sure that we have all of the underlying data. Defendants have said that we do.
Well, see, you got to point me if something's missing. If there's a gap, then I can see the gap. If I say, well, we know that there should be a bank statement for this period, but there isn't one, and there's a blank spot in the record, so I know I didn't get this piece of it. But sort of a general, I'm not sure we got everything when they're representing that they give you everything. That's not enough for me to grab onto.
But they haven't produced hardly any bank records, Your Honor. That's the point. We've had to subpoena bank records. I don't know that the banks have given us everything. I don't even know that we've subpoenaed all the banks that they use.
Well, see, that's a different issue.
And that's what we're trying to get at. We're trying to get at the underlying data, and we don't know whether we have it. And we can answer whether QuickBooks has it real easy by getting an administrative username and password to allow us read-only access to that QuickBooks data. If it's not there, then in fact, we do need to make sure that we've got all these bank statements. We don't know if we do or not.
Right. I understand you're trying to piece everything together through multiple sources, and some may be bank statements. You may be able to cross-reference it to some of the QuickBooks statements, but you don't have that sort of comprehensive, every record that you're not sure that you have every record that forms what's in the QuickBooks.
Precisely.
All right. I think I understand why you're asking it. So, all right, Mr. Raley, I'll let you respond. There was a lot there. I'm particularly interested in the harm, if you can tell me the harm in allowing some limited temporary access through a password, read-only access to the QuickBooks data.
Okay, Judge, let me let me sort of work through, and I'll keep this succinct. What Mr. Toddy is relaying to you is, I may not be a very good communicator because I have told him the answer to a lot of the questions that he's raising and just repeating to you as factual allegations about what does exist and what has been provided to him. But he's continuing not to relay that information to you. And so here is what was produced. And again, every one of these documents that I'm going to list for you here, except for the tax returns, which we've also produced up to date, every one of these documents was produced in native format. First, we produced annual balance sheets along with monthly profit and loss statements. Those are documents that are compiled from information, as Mr. Toddy did correctly report, and those were produced in their native format. We produced, and those profit and loss statements are monthly detailed analysis for the years in question. We produced monthly detailed accounts receivable reports, along with monthly detailed revenue reports. Now, what Mr. Toddy is, again, maybe it was my fault in not communicating this effectively to him. CurePoint outsources the AR and revenue reporting. It's through a company called Radiation Business Solutions, RBS. Mr. Toddy knows them well because he has subpoenaed them as well. And moreover, Mr. Toddy's client knows exactly how all this works. He's in the business. He knows how these things work. And so we produced the records that we received from them, from RBS, on a monthly basis. Those documents are 8 to 9 pages in length each month. They include, line by line detail of the accounts receivable, of the funds that have come in, where they have come in from, who's late, who's early, Blue Cross isn't paying. That it is a trove of information that shows everything that exists about our revenue. Now, Mr. Toddy has come back and said, well, where does the data come from that goes into your financial statements, your balance sheets, your profit and loss? Well, on the revenue side and on the AR side, they come from the RBS reports. They know that. They've been told that. But yet they would like to create the impression with the court that we're holding on to some underlying data. It's just not the case. In addition to the RBS reports, we provided payroll reports. Again, as the plaintiff knows, as Mr. Toddy's client knows, we outsource the payroll to a company called HBS. They send us payroll reporting in an Excel spreadsheet. So that is our original data. That's the data from which our payroll reports come. And they have those documents. We produce them in native Excel format to them the same way that we received them from HBS. So that's our revenue, it's our AR, that's our payroll, the largest expense that we have. And in addition to that, we provided monthly detailed accounts payable reports. That is the one category of documents that CurePoint uses QuickBooks Online for, is for its accounts payable. And so those records, that's the only area that there is any kind of, it's not a dispute, it's a discussion about whether they were provided in native format, but it's the accounts payable that are created in QuickBooks Online. Those reports, as I think Mr. Miles stated in his affidavit and as I stated in my letter to the court, with QuickBooks Online is not QuickBooks Desktop. And believe me, Judge, between my client and me, we have spent, in total hours with the QuickBooks Online help desk. We've spoken to outside accounting QuickBooks experts to make sure, I take the court's orders very seriously in terms of producing in native format. So I checked all the boxes, had the client check all the boxes to make sure we were producing these QuickBook files in native format as the court required. And that is exactly what we were informed. QuickBooks Online says, as QuickBooks Online, you can access those records 3 ways. You can print them, you can save them as a PDF, or you can download them as Excel. Those are the 3 ways for those people who use a cloud-based system, QuickBooks Online, as opposed to a program that sits on their desktop in their office. That is the way it works. And so we took those reports in their native format, which is Excel, and we provided that information as a part of our comprehensive production. All this information was provided on April the 1st. And so those documents, plus the bank statements, which I'll get to in just a second, those documents that is what CurePoint's financial records consist of. That's it. There's not another core, Mr. Toddy keeps saying the underlying data, that is the underlying data. Those records that we produced in addition to the bank statements. And so, you know, at one point, Mr. Toddy he claimed that I admitted in an email to him that the reports were based on other records or something like that. I did not say that. I went back through all of the dialogue between us. What I said to Mr. Toddy was, again, in trying to offer the same explanation to him, the information in the reporting that you received, mainly the balance sheets and the profit and loss statements, the information that goes into those reports is created from the other records that I just listed, created from the records that we provided and that I just listed. There were no other records that are out there that we did not produce on April 1. And you know, as the court can imagine, it's a relatively, CurePoint's a small company, it's a relatively monumental task to be tasked with producing all your records, all your financial records. And we devoted an enormous amount of time to make sure that we did it and that we did it right. And so, you know, we never indicated that there was some record out there that we didn't produce. The only issue, and again, this is to the complaints that I saw in the letter that was submitted. First is with regard to bank statements. My point to the court in my letter submitted earlier this morning is this. We produced on April 1. Mr. Toddy reached back out to me. We supplemented on April 27. We've had 5 or 6 communications back and forth since then. I think one of them was attached. Well, maybe the whole string was attached in Mr. Toddy's letter to the court. The letter of just last week preceding this hearing is the first time that bank statements have been mentioned. There's been no, it's been due to, due from, it's been underlying data, it's been all of this other stuff, very detailed from Mr. Toddy, no reference to the bank statements. And the reason is this: we produced back in 2018, we produced all of the bank records from an account with Morris Bank that we used into 2018. We produced all the records from Synovus, which is our main bank, up until that time. Now, as Mr. Toddy, he correctly pointed out, they attempted subpoenas or issued subpoenas a few times along the way. We objected on different grounds because, you know, we took the position that the dispute cut off at a certain date and they weren't entitled to forward-looking records. But as he said, the court denied a couple of those. One of them was a little unclear in terms of what Judge Bonner ruled, but those subpoenas were issued. We objected to parts of them. The court said, no, you can go ahead. So if Mr. Toddy didn't follow up and get those bank statements, that's a surprise to me. What I was referring to about not objecting was more recently, and I didn't look at the date before I came on here today. I believe it was late, right at the end of 2020, before we rolled over into 2021. Mr. Toddy issued a ton of subpoenas to a bunch of banks, including Synovus, and we did not object to it. So as far as I know, I mean, I don't know why they wouldn't have received the Synovus checking account records that they subpoenaed back at the start of the year, and to which we offered no objection. We simply didn't object. We said, we've seen the court's ruling before, and that's fine. Take those documents, just keep them confidential. So I guess I was surprised to see reference to the bank statements, which are the only thing that wasn't produced on April the 1st. And as explained in my letter, I believe, and in Mr. Miles' affidavit, the company just accesses those online. The company doesn't keep up with bank statements necessarily in a file somewhere like we used to when we only receive those statements by mail. So, you know, it's not something that we have in our possession to produce. Having said that, if all this is simply about the Synovus bank statements, which I presumed that they had because they've subpoenaed them and we didn't object to them, you know, I'll call Synovus today and say, respond to the subpoena. I mean, we're not going to object to it. And if they've asked for those records, and that's what we need to complete the underlying availability of all of the core information, I'll help facilitate that. But we didn't withhold anything because we don't have those records sitting around in a file somewhere. And again, that's the only substantive issue that I could find in the letter suggesting that there was something that we didn't produce. Now the only other thing that I saw was this reference to the beginning balances or an earlier general ledger. the existence of that. And what I would say is Mr. Toddy is overstating the testimony from Mr. Miles. Mr. Miles was clear that what he's describing, Judge, is there was a change in the accounting systems that were used by CurePoint in the 2017-18 timeframe. And so they questioned Mr. Miles about this, and CurePoint previously maintained a general ledger on the old system. They haven't maintained a general ledger in that form coming forward. And so the question was, well, did you bring over that general ledger data that relates back for several years, presumably since CurePoint was formed in 2014? And what Mr. Miles said was, he said, we brought over the beginning balances. So as the court is probably familiar, if you look in a balance sheet, there are categories for depreciation, there are categories for equipment. There are all sorts of categories that they're not really subject to day to day. It's not like expenses that come in this day and a payroll expense or revenue, et cetera. Those are balances that are generally adjusted on an annual basis and carried forward. Shareholders' equity, those kind of things. And so what Mr. Miles testified to was the beginning balances were brought over, and they asked him, they said, what about the underlying data? And he said specifically, I'm not sure. I'm not sure if that was saved. What he indicated was if it was saved, it would not be in QuickBooks. It would be just in an Excel spreadsheet somewhere. But he wasn't sure one way or the other whether that had been done. Now, for purposes of this dispute, what plaintiff has turned that into is Mr. Miles said that he imported all this data and that it exists and they haven't produced it. But that's not what Mr. Miles said. Mr. Miles said he wasn't sure, and they have searched for it and they don't have that Excel, that information is not there. So, again, that was the purpose in part to answer that I wanted Mr. Miles' affidavit to be on file so that the court has before it testimony that shows, we've produced all of the underlying data. And again, I've tried to communicate that as clearly as possible to Mr. Taddy about why the information he was provided earlier constitutes that underlying data. And they've received the financial reporting in the form of the balance sheets and the profit and loss statements. And the fact is, Judge, that the QuickBooks, the reason they're asking for online access, again, other than just general suspicion, is based upon the claim that what we produced was not native format. What we produced was not that this argument that Mr. Toddy has made that the Excel spreadsheet is not a native production of QuickBooks Online. And as I said, we've offered testimony here. I would encourage Mr. Toddy to get on the line with the QuickBooks Online help desk. And I think what they will explain to him is for the online program, that is native format. And so we have done what we were supposed to do. And so what they're trying to do, Judge, here is to bolster this request for online access to our QuickBooks account because we didn't produce the information in the right way. And I would I know the court asked for a response with regard to the harm. And so I would respond just in a couple of ways, Judge. First, I do think it's important to remember in this larger context here, the plaintiff is not an owner of CurePoint. The plaintiff is the owner of a minority interest in PFP, which is a party to this case, which owns the majority interest of CurePoint, among other assets. So PFP is an owner of CurePoint. The plaintiff in this case doesn't own an interest in CurePoint. And point, I think it's worth noting for the court, is not a party to this case. So I think sometimes in all of this, we lose track of, let's take a step back because I will tell you, Judge, I looked after I've seen this suggestion from him for online access. I can tell you, I was unable to locate a single case in Georgia that authorized that kind of access by a member of an LLC. As the court is familiar, there's a member inspection statute, one for corporations, one for LLCs. And for the LLCs, it's 1411-313. It comes up a lot. in these kind of disputes. And what that statute provides is that a member is entitled from time to time, upon reasonable demand, information concerning the state of the business. That's what the statute provides. Now, granted, that's broad. But even with that broad language, there aren't cases in Georgia that support minute-to-minute, day-to-day access by a member to, again, if the logic that Mr. Toddy is employing here were correct, then I suspect a member would be entitled not simply to access to online accounting, but to bank records online. You can read only, to emails online, read only, to that sort of minute to minute, access to those records. That's not what the member inspection statute, that's not what Georgia law authorizes. They're entitled to information from time to time upon reasonable demand, which is what we're doing and what the court told us before. Provide this information to them. Mr. Raley, you're under a duty to supplement. Remember, they asked in a prior order for the court to specify the supplemental time frame, and the court said the statute says you're under a duty to supplement, which is what we're doing. And I think one of the bases for this point, the reason we raised the issue of the plaintiff, Mark McCord's status as a competitor, Judge, we've already sort of seen this. The plaintiff participated in a motion for receivership down in Lawrence County at the end of 2019, where an entity of which was owned by the plaintiff's family and indirectly by plaintiff, he admitted having an ownership interest, and he took the stand in front of the judge in Lawrence County and argued that without evidence in that instance that PurePoint was not paying its bills as they came due. PurePoint in an immediate fashion was not able to pay their accounts, and supported a request for PurePoint to be placed into receivership in front of the Lawrence County Superior Court. Now, so we've seen what, and in that case, Judge, as it turned out, the motion was denied because PurePoint was keeping up with its bills. It was paying its accounts. They didn't have any evidence to the contrary, but the plaintiff tried. He tried to go in there, and so that's one of the reasons, Judge, principally, that I think should factor into this request for, again, minute to minute, day to day, week to week, hour to hour access to our online financial records. I mean, PurePoint, again, a non-party to this case, should be, it needs to be able to conduct its business and provide the information required by law back to the plaintiff as even though again, we understand the court's ruling, but he's he's not even a member of PurePoint, but we should be permitted to provide the information that the court has required us to provide without that kind of intrusion and potential harm. Now, Mr. Toddy can say, well, there's a protective order. There's been a protective order throughout these cases. It certainly didn't stop the plaintiff from taking the stand in Lawrence County and saying, these guys aren't paying their bills as they've come due. If he gets on there, let's say next week, and says we're behind paying XYZ vendor, they can file another motion, and he can say, maybe without revealing the direct vendor in question, that PurePoint is not able to keep up with their bills as they come due. Again, it's based upon my research, Judge. It's a drastic step to require that kind of access just based on, in this case, an indirect membership. So it's drastic, number one. And two, I think before the court can get to that drastic, or should get to that drastic step, it should ask itself, what has PurePoint done to justify the request? And in this instance, as we've said, we did the research on what is a native file in Excel, on QuickBooks Online, and we produced all of our financial records. So what violation has occurred that would justify this drastic step of permitting an adverse party who's in competition with us on a day-to-day basis to be able to look at our records and track in a minute-to-minute basis. So that's all we're trying to do, Judge, here. And again, as I said, I take the discovery orders seriously, and I will state on the first issue, I should have seen around the corner and made sure that inflows outflows was produced initially. But other than that, which we corrected once Mr. Toddy reached out to us, other than that, we have I don't think there's been any evidence to suggest that we haven't done everything that the court asked us to, which was substantial, and complied with everything, and continued even to avoid having to have a hearing today. I sent a point-by-point response to Mr. Toddy to all these issues raised today, and I never received a response back. Never received a substantive response back when I was saying, tell me what we need to do to avoid having to waste the court's time. So, we're doing everything that we can, and I just don't, there's not a basis, again, in our humble opinion, for the court to take that extra step of requiring some kind of online access to a competitor.
All right, Mr. Toddy, you get the last word.
Yeah, so there was a whole lot of information there. I'm going to try to be concise and brief here. With regard to Dr. McCord's participation in a receivership hearing down in Lawrence County.
You don't even have to respond to that. I don't think that's material to what I'm
really, all it goes is to show that Dr. McCord doesn't know what's going on in this company. He's not using any access improperly here, any access he might have to financial information improperly here. Second, at the beginning of this lawsuit, Dr. McCord made a request under the limited liability code for access to the financial records of CurePoint. Defendants objected to it, fought Dr. McCord on it, and the court ruled against them and said that Dr. McCord, as an owner of PFP, which at that time at least was the 100% owner of CurePoint, Dr. McCord's entitled to CurePoint's financial records. That issue has already been decided long ago and repeatedly by the court. Dr. McCord is entitled to access to these records. There has not been any allegation that Dr. McCord himself has ever done anything improper with any of the documents or financial records that he's obtained or financial information he's obtained regarding CurePoint. I want to look briefly at Mr. Miles's testimony regarding the prior accounting system. So he's asked, why was the change made to QuickBooks in January of 2018? Thomson Reuters, effective December 31st, 2017, cut off its client bookkeeping solutions. Question, so was the historical data that was in the Thomson Reuters system imported in the QuickBooks system? So let me answer that thoroughly. It was imported to CSV, then into Excel, and then into QuickBooks, okay? So the answer is yes, there's a couple of steps. I wanted to be thorough. Asks about what CSV is, says, okay, then it goes into Excel, and then from there into QuickBooks. That is correct. So today, if you looked on the system that Eclipse has access to, you could see the historical data for both entities all the way back to their inception. He says, beginning balances were entered into QuickBooks. Historical balances may or may not have been saved on CSV or Excel file. I'd have to check that. Was there a general ledger maintained for either entity in the Thomson Reuters system? Correct. He says there was a general ledger. And is that data in the QuickBooks system? It says historical information is not in QuickBooks. Beginning balances are in QuickBooks. Okay, historical information is maintained outside of QuickBooks. Where is it maintained? It would be in an Excel file. So in other words, there is an Excel file with a general ledger, at least through 2017. We don't have that.
Judge, I'm sorry to interrupt. I have to object. If he will read the next two sentences, then that will be a full recitation of what Mr. Miles said. I'm sorry to interrupt, but I think that's completely misleading to stop there and not read the next two sentences.
Okay, the next two sentences, the question, okay, and is that Excel file located on a computer at Eclipse? It should be. I'm not 100% certain though. So he doesn't know where the spreadsheet is located, but the existence of the spreadsheet, he says it does exist.
But if he doesn't know, and he testified he doesn't know, how can I enter an order directing him to produce it or find that there was some kind of willful failure to produce it?
The way we get around this, Your Honor, the way we get around this, and here, let me stop sharing here. The way we get around this is we allow Dr. McCord to have temporary read-only access to the QuickBooks files, to the QuickBooks records. It doesn't have to be minute-to-minute ongoing access. If we can have temporary read-only access to the QuickBooks records, it would address this. And then we can work with Mr. Raley about the bank records issue. The problem with the records that have been provided to us is that it does not give us a complete picture of CurePoint's financial situation. And in fact, it's missing the most important part. Dr. McCord is alleging that the defendants in this case have taken money from CurePoint improperly. They've engaged in voidable transfers where they have taken money out of CurePoint and paid themselves or entities that they own and control money from CurePoint, excluding Dr. McCord as an owner of PFP from those distributions or from those payments.
Let me interrupt. Let me stop you for a second. Wouldn't bank statements show that?
They very well might. Yes,
So,
they might. And in fact,
I'm trying to understand why QuickBooks is the best source of that information. If that information is coming from the bank statement and you've got access to the bank statements, I'm having trouble making that connection as to the necessity for all of this introspection into QuickBooks.
Because we don't know if we have all of the bank statements. We have had to fight for the vast majority of the bank statements that we've received in this case. The bank statements
but we know, let me stop you. Let's drill down a little bit more, all right? Because I've heard about Novus Bank and I've heard about the bank before that, and there may be another account out there somewhere. This is trackable information, right? If you got a bank account that's in existence over a period of time, I think we can determine with some detective work if there's a gap in the bank records. Now, unless there is a completely different account out there that nobody knows about, and looking at the QuickBooks file isn't going to disclose that, because it's not, if they're hiding an account somewhere, it's not going to be in the QuickBooks file. So I'm trying to understand the necessity for this, how this is going to lead to something that helps you prove your case.
So we've heard that there are, and they did in fact produce balance sheets, monthly profit and loss statements. Those documents, and as well monthly accounts payable reports, those documents, and perhaps I misunderstood Mr. Raley, those documents were generated from the QuickBooks files.
Incorrect. That's incorrect, Judge. And what I have said, and again, I look back, it's in emails to Mr. Toddy. I've tried to be consistent and clear. The QuickBooks files for CurePoint are used for accounts payable. All of this other information is not maintained in QuickBooks. It's outside of QuickBooks. Even the ledger that Mr. Toddy was referring to a second ago, that document would not be in QuickBooks. If you look at the testimony he pulled up from Mr. Miles, 3 lines above that, he said that document would not be maintained in QuickBooks. That's not what we use QuickBooks for. So that's one of our issues here is the QuickBooks. Yeah, you're exactly right, Judge. They're trying to solve the problem by going to a place that we don't even use QuickBooks for. I mean, the balance sheets and profit and loss statements are generated in Excel from the information that we produced and were provided to Mr. Toddy in native format.
What information did you produce generated those monthly profit and loss statements? That is not a correct statement. You have not produced the underlying data for that.
Yeah,
All
no,
right, all right,
Yeah.
I'm gonna stop the back and forth and, you know, we've been going at it for an hour and I think I've heard enough. Mr. Toddy, I understand and I empathize with your suspicions and I understand that that you're having to chase down the rabbit hole and you don't know where the end of the rabbit hole is. The problem I've got is that what I have mostly is suspicion, but I don't have anything substantive that suggests to me that they're willfully withholding a document or some category of documents. You know, I have to look and I have to ask myself, you know, have they done a diligent search and in good faith produced what they have? And I agree with you that they should have produced at the outset those in and out cash flows. That was not fully compliant with my order. But you pointed it out to them and they went and they supplemented their production and they corrected it. There's hassle and I acknowledge the hassle and they shouldn't have put you through that hassle, but it was done. It's not, and there's nothing that you pointed to today or in your letters that tells me that there's some category of documents or some piece of a category that's been withheld. And we've now got Mr. Miles testifying on oath, under oath, that they produced it. So if you have something more specific that you can say, ha, he said this, but this is not true, and here's why, then, you know, I'm prepared to consider the more invasive suggestion. All right, let's get in there, or let's get someone independent in there to really get in behind the password and start digging through everything. But you know, I think given how contentious things are with these parties, and given the level of effort that I acknowledge has been made by the defendants to respond and to continue their dialogue with you, because it's not like they're not engaging with you when you say, hey, where is this? Where is that? Why haven't you produced this? Explain it to me. They're engaging with you, and I believe, and from everything I'm hearing, that they're engaging in good faith. You're not completely satisfied with that. I get it, but I do not see enough here to order any additional relief that you request at this time. That's my ruling. But without prejudice, if you got more, come back to me. Let Mr. Townsend know, and we'll talk about it.
What I think what we'll have to do is subpoena RBS and take RBS's 30B6 deposition. I think that would be helpful for us. So thank you, Your Honor. I understand. We will work with Mr. Raley to do some additional discovery here, and we'll come back if necessary.
All right, very good. Thank you. Thank you both, counsel.
Judge, thank you.
Thank you.
All right, and try to enjoy Memorial Weekend.
You too, Judge. Thanks.
Thank you.